Gentleman from 15.
Thank you, Mr. Speaker. I rise to debate in favor of the bill. There's been quite a bit of discussion here about both global constitutional issues and also policy. I'd like to touch on both of those. There's been discussion about secession, civil war, riot, all that kind of stuff. And I'd just like to direct you to paragraph 3 of the bill, page 2. This goes to the intent of the bill. There's two parts to the bill. There's the intent, and then there's the actual policy. What are we going to do about it? And paragraph 3 refers to the reserved powers that I don't think anybody here disagrees that our Constitution provides under the 9th and 10th Amendment that there are certain powers reserved to the people and to the states. And where those powers are reserved, it's incumbent on the states to identify where that line is. I'll just read from the bill. The states and people having reserved powers under the United States Constitution to themselves, it is incumbent upon the states, including Idaho, to ensure on behalf of their citizens that the powers reserved to the people and states are not diminished through the assumption of non-delegated powers by the federal government. To identify such encroachment and peacefully and lawfully oppose and resist it is a natural duty that flows from the powers reserved. Well, now what does that mean? Basically, it means we have to look at what comes out of Congress and say, is this constitutional or not? If we don't ask that question, we have no 10th Amendment, we have no 9th Amendment. We've given it all away. So it is incumbent upon us to be asking that question when laws come out of Washington. Is this a constitutional exercise of authority? Well, is this nullification? I don't think so. It's taking care of our duty to enforce the 9th and 10th Amendments, which we, as a state in the Union, have adopted. The fact that we've actually gone to court supports the point that we're trying to do this the right way. We filed a lawsuit with 26 other states, and what happened in that lawsuit? We won. The court said this law is unconstitutional. So that leaves us with a decision. We have a court order that says the law is unconstitutional. It's an order that applies to us because we're a plaintiff in the case. So now, as a policy-making body, we have a decision to make. Do we implement an unconstitutional law or not? My answer is no, we don't. And we don't somehow violate our oath of office or violate the Constitution by doing so. We're making a policy decision based upon a court decision that we won to implement a policy that says, no, we're not going to implement the provisions of an unconstitutional law. Now, some may say, well, there's other decisions out there that go the other way. Well, you know what? Those are not our cases. Our case is in Florida. We are a plaintiff in that case. We won that case. Let's talk about Arkansas for a minute. Well, what happened in that situation? The court ordered desegregation. And that's a different situation than here. In our case, the court ordered this law is unconstitutional. We're following the order of the court. I think the good lady from in the corner, District 2, really hit it on the head. Once we go down the road, we're roped in. We have no choice. And our choice here is to follow the order of the court in our case, which is to not implement an unconstitutional law. Thank you.